Okay. Oh, my goodness, there is an uptake. We're going to work on that for a second. Okay, I'm going to call to order the Thursday, November 20th. It's still a lot of feedback there, Mary. Is there a way to take that down? Is that loud to you guys out there, or is it just loud to me? Or maybe I'm sitting where I know I'm not supposed to sit, and that's what's getting me in trouble. Okay. Well, I'm calling that sounds better, calling the Thursday, November 20th, 2025, regular docket meeting for the Minnesota Public Utilities Commission. My name is John Tuma. Chair Sieben has asked me to preside over today's meeting. I thought I'd sit in her chair, but not actually physically in her chair. I moved mine over here. I just wanted to be behind my wife's lovely quilt that she made. So, for the record, if I don't get the chairs changed back, it's your fault, okay? So remind me, commissioners, to change the chairs so Katie's not mad at me for messing her chair up. So, my thinking today is we do have 6 items, but my hope is, knock on wood, that they will go relatively quickly. So I'm not planning on taking any lunch breaks. Maybe take a break between 4 and 5, but we'll play that by ear. If you need to obviously stop to talk to staff or need a break for other reasons, just let me know. We've done this before, nothing new. So with that, I'll take the roll. Commissioner Partridge.
Here.
Commissioner Hom.
Here.
And I am here, so that makes a quorum, just barely. But with that, Mr. Mohammed, why don't you formally introduce item number 1?
Good morning, Chair Tuma, Commissioners. Item 1 on the agenda is G-008/E-25-286. In the matter of CenterPoint Energy's Minnesota gas petition for approval of its annual depreciation study filing for 2025. The question before the Commission is, should CenterPoint's 2025 annual depreciation study be approved? Staff and parties are available for questions. Thank you.
With all the items today, I don't see a need for opening statements, so we'll go right to questions and discussion. So, Commissioner Partridge.
Thank you, Chair Tuma. I did have a quick question for the company. I'm not sure if they're in the room or online.
Looks like he just popped up online.
Oh, great. Mr. Demerit, I see you. Would you introduce yourself?
Yes. Good morning, Commissioner Partridge and Chair Tuma. Seth Demerit on behalf of CenterPoint Energy. And with me, I have Jessica Bernard.
Great. Thank you. I have a quick sort of a question, but also just something to flag that I'm interested in learning more about in the future. I didn't have any questions on your current filing. Everything seemed to be buttoned up by you and the department throughout the docketed process. I should start by saying thank you to Mr. Mohammed for doing such a nice job on briefing papers and for answering all of my detailed questions so that I don't have questions to ask the company today. One thing I did notice was that you are investing in the geothermal network system. I'm assuming that's through NGIA, or are there additional geothermal infrastructure projects that you're working toward?
Thank you, Commissioner Partridge and Chair Tuma. That is specifically related to the thermal energy networks or geothermal networks that are part of our NGIA plan. So just starting to think about the depreciation process for that.
Great. Thank you, Mr. Demerit. And you've just told me, and I assumed that you're just starting to think about the depreciation process. I had staff kind of pull up for me the expected lifetime and the term over which we're depreciating other parts of your system, other materials and infrastructure that you have. And I'm interested to see, and you may not know this now, but I'm interested to see over what term you expect these geothermal networks to be depreciated, or what you expect their service life to be.
So I would say that that's largely to be determined. I think part of the questions that we have is I think there's the different components of the geothermal network systems. I think there's going to be a lot of the in-ground piping that is going to be very similar in life to our current natural gas system, just similar in nature, but not necessarily, not exactly. But there may also be, additionary components that go along with these systems that we just need to consider, and they may have. I shouldn't say they will most likely have separate depreciation lives for each of the individual components, and so that's what we're working through and thinking about as how to address.
Great. Thank you, Mr. Demerit. That answers my question. I'm just interested in seeing that in the future. It's always helpful for us to understand as you guys make these investments, really, how long are you expecting them to be in service? And especially when they're new like this, to really get a better sense of what your expectations are and how that affects depreciation and rates. So that's all I had to flag if others have questions.
Commissioner Hom, I don't have any questions.
Great.
So let's go to
I can make a motion.
make a motion, yeah.
Excellent. Okay. My motion is decision option number 1, number 2, number 3, and number 4.
That sounds good to me, Commissioner Hom. Okay, let's vote. Commissioner Partridge. Oh, that's, we don't have to be in line. I was thinking they had to do that. So all those in favor, signify by saying aye.
Aye.
All those opposed, same sign. Motion passes unanimously. You got number 2 also. Fire away.
Item number 2 on the agenda is docket number G-002/M-25-277. In the matter of Xcel Energy's 2024 annual report of rate case approved throughout mechanism and proposed electric refund and gas deferral plans. The question before the commission is, should the commission approve Xcel Energy's proposed 2024 combined residential electric refund plan and 2024 combined gas customer deferral plan? Staff and parties are available for questions. Thank you.
Excellent. We'll go right to questions. Commissioner Hom.
Thank you, Chair Tuma. Unless the commissioner has any question, I am ready to make a motion.
Sounds good. I do not have any questions. Do you, Commissioner Partridge? That's a question, though.
Yeah, the only thing I had flagged for us to talk about was the participant compensation as being part of the transmission rider.
I think
Oh, that's the
3.
next one. I'm sorry. I apologize. I am ahead of myself. I have no questions.
That's good, because now you flagged it. What I
There
was
we
going to
go.
flag, and I think
Great.
we're all flagging that one, so we're all prepared. They will be prepared to discuss that, so
Sorry about that. No questions on this one.
go ahead, Commissioner Hom.
Okay. Thank you, Chair Tuma. So I'd like to make a motion to move decision option 1, 2, 5, 6, 9, 11, 13, 15, 17, 18, 19, 20, and 21.
Now that I think about it, I did have a question for Xcel real quick. Whether the settlement, what the ETA on the settlement is. Now that I sat there and then you made the motion, I saw. So go ahead. Mr. Dobson, state your name for the record. And
Thank you, Mr. Chair. Had to make sure I got that one right. Ian Dobson with Xcel Energy. I'm sorry. I'm
ETA on the on nuclear settlement money.
Oh, sorry. I was. Yeah.
You're already preparing for participation comp already, right?
That one's not me. But the best answer, and it's probably not a very satisfying answer, is we just don't know. The government shutdown sort of stopped that up, so we're waiting for it. We don't have any reason to think we're not going to get it. We just don't really know when it's coming in.
And there'll be no problem bifurcating that, so if the settlement comes in, there it's going to be refunded to the ratepayers ASAP.
Correct. We'll get that out as quick as we can.
Okay. I have no further questions. Hearing none, all those in favor of Commissioner Hom's motion signify by saying aye.
Aye.
All those opposed, same sign. Motion passes unanimously. Now, Mr. Willett, we have the Transmission cost recovery docket for Xcel. Mr. Conlon, you might as well come on up because I think there's a question, so.
Good morning. Item number 3 is docket number E-002/M-24-371 in the matter of Xcel Energy's petition to approve the transmission cost recovery rider for 2025 and revised adjustment factors. The question in front of the commission is, should the commission approve or modify Xcel Energy's 2024-2025 transmission cost recovery rider revenue requirements and resulting adjustment factors? And parties and staff are available for questions.
Commissioner Hom, we'll go to you. You don't have to start with participation comp if you want. You can start with wherever you want, but I'll let you lead off with questions.
Thank you, Chair Tuma. I think that's the one I want to start today, and there is some proposed alternative motions.
So Mr. Davis, I think, is getting up some language.
So I'll ask a company, do you have any concern with this modified language? And then also I'll ask a department.
If you got a physical copy, I'd take one. Looks like they're consulting, so we'll just take a second to let them talk through it. Mr. Conlon.
Mr. Chair, Riley Conlon on behalf of Xcel Energy. Mr. Chair, Commissioner Hom, while we don't overall have any concerns with the motion as drafted, I think to back up as to why we used the TCR as a place for this proposal was under the statute, we viewed it as a rider that would be considered a proceeding under the intervenor comp statute. And because it's a tracker that is in existence, it would be an efficient way to flow these dollars when it existed. The current balance of the state energy policy rider is there's nothing in it right now. And so it is a relatively small amount of money to use that rider for. But if that is the commission's desire, we're happy to do that.
Thank you, Chair Tuma. Yeah, I think advice I got on this issue was I think a TCRR statutory language is very clear. So we had some concern with flowing this through that TCRR. So I think I'll ask a department on that too then.
Sure. Ms. Campbell, state your name for the record. Let us know your thoughts.
Nancy Campbell for the department, and with me I have Mark Johnson and Mike Bologna. I think we're fine with this. We did feel like this was a legislative requirement to get this participant compensation, so we really didn't have problems with the recovery. And so if the commission is concerned that it shouldn't go through the TCR and instead should go through the state energy policy rider, SEP-rider, we don't really have any concerns with that. We did probably think it was just more efficient and felt like since the bottom line was they could recover it, that's why we probably let it go through the TCR rider. But we don't have any concerns with if you'd prefer it to be through the SEP rider.
Commissioner Hom.
Thank you, Chair Tuma. Yeah, I agree that I think we have to make sure that that company has the ability to recover this one as soon as possible. That's a statute, but also we have a TCRR statute. So that's why I had some concern that we are flowing it through to TCRR. And then advice I got is I think a state energy policy rider is more appropriate to flow through this kind of cost. So, but also Xcel raised a good concern. You may need another line of the bill with a very small amount. I don't know how much it will show up in the individual bill if this small amount as a separate item, whether even it can show up in the bill as an individual residential customer bill if they are so small, right?
Mr. Chair, Commissioner Hom, I know the overall amount in this year that we proposed in the rider was approximately $72,000, and so not able to do the math here, but it would be a fairly small line item if even large enough to exist at all. I could check on that for you to see what it would look like in terms of a single item on a bill.
Commissioner Hom.
Yeah. Under that circumstance, can you just defer this one for next year recovery since it's so small and then using that state energy policy rider, or are you just recover through the rate case item? I don't know whether we can introduce new item through the existing rate case, but yeah, I want to make sure that administratively it should be efficient. I don't want to waste a lot of money for very small amount of money either. But also we have a statute, so I am just torn in this too, that we have a statute on the TCRR, and then also you should recover this cost, but also amount is so small, and what is the best way to deal with it?
Mr. Conlon, here, I'll just throw an idea, just my brain going. When is the state regulatory rider typically brought before us? And why couldn't, because it's so small, and I don't know if we've put a lot of money through it in the past, what reason couldn't we do them together? I think with Otter Tail, we actually allow them to collect a couple different things under a combined rider, and just the language just needs to be, it's both. So I'm kind of wondering why we couldn't just have you file the state rider at the same time you file this, and we combine them and have a notice, and it's going to end up on the same one. You know, this one we could just combine it knowing that's going to happen. So I don't know if that's a possibility, because if there's nothing there now, it doesn't sound like you're going to probably file one in March. You could just delay the next filing for the state regulatory one till this one is due. I don't know when you file this one. How is that?
Mr. Chair, Commissioner Hom, appreciate the question. Mr. Dobson just provided me with some other insights. We could also propose as using it as an offset to interim rates in the current case, and that might be, also accomplish what we're looking for. So
Right.
Would that be potentially workable from the?
Well, your other option is to do it as a rate case amount. You know, for example, we have your property taxes, you know, which fluctuates and it's trued up, and we could create a thing through your rate case process to do a similar thing there, which to me would be the most logical place to do it, but it's such a small amount of money that it gets to be cumbersome to throw it into a rate case when you got, you know, $1 million decisions, and we're just trying to keep track of this $75,000. Ms. Campbell, I threw out a couple different options to try to resolve this, and I'm looking to you to find out what's most efficient for you.
Sure. Actually, I think an offset to the interim rate refund would probably be pretty straightforward and pretty easy to do. We have done that with other things. I think the one thing about putting it in the rate case is this number could be kind of volatile, and so building it into base rates when we don't have a lot of experience is not probably my favorite idea, at least at this time. So I think in the interim rate refund, that's fine. I think we're going to be in a refund situation, so just offsetting that amount will be, it's small, so.
Yeah, I think at this stage, I would say, let's do it in interim rates, get the right word out. But I would say consider maybe combining the state policy rider with the TCR rider, and just a matter of writing the notice is be a thought. I mean, I don't want to make that decision here because we're kind of doing it on the fly. So I guess I would throw that back to you to figure out a way to do this more efficiently. I had no problem doing it in this one, but I was concerned about how it would look, and so I want to make sure I'm not running down a road that my other commissioners don't want to go. And interesting, I went back and looked at the conversation we had a year ago on this very topic, and the two commissioners that were most vocal on this are not here today, and so that it was making me a little nervous of how to handle this permanently going forward. I think there is a permanent way to do it in a rider, and I would be supportive of that. But I think the solution of doing it in interim rates for now and leaving it for a future discussion on a future rider would be a good move. Commissioner Hom.
Thank you, Chair Tuma. In that case, I need about 5 minutes to consult with our legal.
We will take a break until 10:30. We will come back. Commissioner Hom.
Thank you, Chair Tuma. Okay, first of all, there is some concern with using rate case at this point because it was not noticed to rate case parties. So we have that concern, and also there is no guarantee that there will be a refund to the ratepayers in the interim rates. So the prejudging the result of the rate case is also very dangerous. So that's the legal advice I got. So being said, I misinterpret what this language when I was advised with this language. Intent is you are going to recover money here. Just you need to change your notice, telling your ratepayers that you are adding two different riders to the TCRR recovery section of it. So we are separating this item to the state energy policy rider because it's so small. Still, you are recovering it through TCRR line item, but you put that in your notice language saying that this item is added to it. So that was the intent of this original language, but I didn't understand that process. So is it okay with Xcel under that circumstance?
Mr. Chair, Commissioner Hom, give me 1 second to just confirm that that works for us, and then I can respond.
And Ms. Campbell, we'll just want to hear from you guys too.
Mr. Chair, Commissioner Hom, that works for us. Thank you.
Ms. Campbell?
The department doesn't have any concerns with that.
This looks like a very good compromise, Commissioner Hom. Any other questions on other topics in this docket? Doesn't seem like we have any other ones, so we will go to motion first. Commissioner Hom, even though it's there, I think that's what's going to be your motion, but should make it.
Thank you, Chair Tuma. Yeah, as you predicted, I'll make a motion to move this proposed in the screen, 1A, 2, and 3 as modified.
All those in favor signify by saying aye.
Aye.
All those opposed, same sign. Motion carries unanimously. Ms. Winter. Recon petition. And as we know under our rules, we do not have to take questions or discussion, but we need to consider it. So, Ms. Winter.
Good morning, Chair Tuma and Commissioners. Agenda item number 4 is E999/CI-23-151 in the matter of an investigation into implementing changes to the Renewable Energy Standard and the newly created Carbon-Free Standard under Minnesota Statute 216B.1691. The question before the Commission is, should the Commission grant the petition for reconsideration of its September 16, 2025 order submitted by Carbon Solutions Group? Staff has no further comments, but is available for questions. Thank you.
Excellent. Commissioner Partridge.
Thank you, Chair Tuma, and thank you to staff for your excellent briefing papers on this. I will just start by saying that staff on page 6 of the briefing papers lay out the reasons the Commission would typically reconsider one of our orders. That is, if the petition to reconsider raises new issues that are not considered on the record, if it identifies new evidence not considered on the record, if it exposes errors in the order, or otherwise persuades the Commission it should rethink its decision. I concur with staff that CSG's petition has done none of the above in my mind, and I do not personally want to consider CSG's arguments. However, I did want to respond to certain assertions made in the petition and correct those misunderstandings. One, the petition repeatedly names commissioners, mostly me, but others too, and specific parties in this docket, describing our mental state as confused. I am not confused, Mr. Daly. I understand what the law says, and I also understand my obligation to follow the law. Your position is not consistent with Minnesota law, and more specifically, it contradicts Minnesota law. Let me remind you of what the law says to clear up your confusion. The law says an electric utility's annual purchases from a regional transmission organization net of the electric utility's sales to the regional transmission organization, but only for the percentage of annual net purchases, is carbon-free. And while I have your ear, even if your proposal were permitted by law, which it is not, in my opinion, your proposal would increase costs to comply with the carbon-free standard to Minnesota ratepayers without commensurate public interest benefits. That, in my mind, is also disqualifying on top of the fact that it is disqualified because it contradicts Minnesota law. I'd also offer a general tip that just because people disagree with you, it does not mean they are confused. It is possible for people to disagree with you. Number two, I don't know why you thought it was appropriate or relevant to reflect on your perception of my emotions related to the One Big Beautiful Bill. In your conclusion to your petition, you state, Commissioner Partridge expressed dismay regarding the federal passage of the One Big Beautiful Bill and this is the important part, and its perceived negative impacts on carbon-free facility deployment in Minnesota. That is incorrect, Mr. Daly. Feel free to rewatch the hearing. I was and am upset that this new law will directly increase costs of energy for Minnesota families and businesses that are already squeezed by increasing costs across our economy. That is what I was feeling and continue to feel. You continue, it's important to remember that President Trump and Congress were voted into office by the majority of Americans. And as such, the current administration and Congress are reflective of the political will of the majority of the country as of November 2024. I fully agree with this statement and would note that no one made any statement at that hearing or in the record to question the validity or credibility of the 2024 election and its results. Your statements are misguided. I find them inappropriate and wholly irrelevant to the petition that you filed. That's all I have, and I can make a motion unless other commissioners have other clarifications.
Assuming that your motion is to deny, all those in favor of Commissioner Partridge's motion signify by saying aye.
Aye.
All those opposed, same sign. Motion passes unanimously. Thank you, Ms. Winter, for your thorough briefing as usual. I'm feeling like we're moving along pretty good, so I'm ready to keep going. So, Mr. Fournier, coming back from the North Woods, good to see you. And the parties, why don't you come up, because I anticipate there will be discussion on this docket. Go ahead, Mr. Fournier.
Good morning, Chair Lumen, Commissioners. Item number 5 is docket number PA-25-279 in the matter of the joint application regarding transfer of control of Lumen's Minnesota mass market fiber business. The questions before the Commission are, 1, is the Commission approval of the transaction necessary? 2, if the Commission determines that approval is necessary, should the Commission approve the transaction pursuant to Minn Stat Sections 237.23 and 237.74, Subdivision 12, and any other applicable statutes or rules, including the grant of all consents and approvals from the Commission necessary to carry out the transaction. Since the briefing document was published, 2 documents were filed in this proceeding. The first was a settlement agreement filed Friday, November 14th between the applicants, AT&T and Lumen, and the interveners, the Legal Services Advocacy Project, OAG, and Department. Subject to the settlement conditions, the interveners agreed to withdraw their opposition to the applicant's proposed transaction and recommend commission approval. The second was staff's filed revised decision option number 3 on Tuesday, which restated the commission's approval of the transaction subject to the settlement agreement identified above. I have no further remarks, but I am available for questions. The parties are available for questions as well. Thank you, Mr. Chair.
Thank you, Mr. Fournier. Before we dive into questions, why don't we just get the awkwardness out of the way? Mr. Top, we'll start with you and head from my right to my left, if you could.
Thank you, Chair Tuma. Jason Top from Lumen. Also have with me a number of representatives from the company.
I see that.
Thank you, Chair Tuma. Pat Zomer on behalf of Forged Fiber, the AT&T entity involved in this proceeding, and we have a number of AT&T representatives here as well.
Forged Fiber, I like that. It's kind of a nice, kind of kick back to the old days of forges to fiber today. So good briefing. Go ahead.
Good morning, Wendy Raymond for the Minnesota Attorney General's Office, Residential Utilities Division.
Mr. Raymond.
Good morning, Chair Tuma, Commissioners. Richard Dornfeld, Assistant Attorney General, appearing today on behalf of the Minnesota Department of Commerce.
Good morning, Chair Tuma, Commissioners. Lisa Gonzalez, an analyst with the Department of Commerce.
See you again, Ms. Gonzalez. Is there anybody online who is a participant or intervener that needs to just announce yourself? Please do it. Turn your camera on and do it now. I'm not seeing anything, but I don't get all the cameras in front of me, so you just have to turn your mic on and speak, and you will appear. I am not seeing any. So with that, we'll start off with our friends from Lumen and Forge. And I see that when I looked at the settlement, CWA did not sign on, okay? But you do have a prior settlement, which I don't think you need to disclose to us. That makes sense. That's a labor issue between you. But obviously, we put a lot of value in what our labor folks have to say on this issue. It was what that kicked off the initial complaints that were in front of us prior. That's kind of intermixed amongst the settlement. And so I guess I just want to understand what that means. I don't see them online, and I don't want to be calling people out unless they want to come forward and speak. But it does matter to me what that means, that they weren't a signature of the regulatory settlement that is in front of us today.
Thank you, Chair Tuma. The CWA, we reached a labor agreement, sort of a nationwide labor agreement with them, as did AT&T, that addressed their concerns with this transaction. So they weren't directly involved in these negotiations, and I wouldn't want to speak for them, but what I can say is that the commitments in this settlement agreement probably go beyond what was accepted by the CWA as sufficient to address their concerns. So I would expect that they'd be fully supportive of this settlement agreement and supportive of this transaction being approved.
And to our public agencies, if you heard anything different, or do I need to view this any differently than what was presented to me there?
We greatly value CWA's participation, and they've been aware of the settlement negotiations and conversations.
Good. Mr. Dornfield?
Chair
It's okay.
Tuma, Commissioners.
I've been insulted, but that's not an insult.
As Ms. Raymond indicated, we consulted with, made CWA aware of these negotiations and valued their input and insights. And I think the settlement agreement, at least in part, reflects what they shared with us and their concerns.
And that's, you know, as I look at this, there are a lot of, I would say, labor issues in the settlement that you've agreed to. And they're very good. They're things that we're concerned about, and that's number of technicians on the ground. Let's just kind of, I want to work with that and to understand that. So just if I look at 1.1 of the settlement, and just take that for an example, okay? And here's where you talk about number of technicians per line. And so I did the math. We're talking somewhere right around 147 technicians, depending how many lines there are. And so the way I read this is this is a regulatory floor to what can happen. And so if the agreement they have with Forge and Lumen is that they should have 150, okay, and they file and say, yes, we have 150 because we have a contract agreement with them, they meet the regulatory floor at that stage and we're fine. If they have agreement, okay, with them to say it's 145, okay, and they report to us, it's 145 and that's what our contract with the union says, then the union wouldn't have an action to bring against them, but CAW or you could come here and say, sorry, that does not meet the floor that was set here in 1.11. Is that your understanding of how this works?
Chair Tuma, Commissioners, yes, that's generally how we thought about this. These numbers are not public, but we did attempt to sort of arrive at a ratio that based on the number of technicians the company has today and the number of lines that it has approximately today will largely hold the post-transaction status quo consistent with the pre-transaction status quo. It's not one for one, but it's relatively close. And then over time, we're having sort of a thoughtful sort of step down as the company's total number of lines shrink. And as you point out, Chair Tuma, regardless of what agreement the company might have with CWA, we're going to be closely looking at what they file and ensuring that they stay in compliance with the ratios here.
And I want to be, the settlement, is that public? I'm just speaking hypotheticals. I can't remember what's public and not public here, so.
Chair Tuma, the settlement is public. We filed it as public.
But the CWA agreement, which I have no idea what it is between you guys, so it's not even in the record if I understand it, Mr. Top, is that correct?
That's correct.
That's right. So I'm speaking hypothetically.
Sure.
I'm not just trying to understand it. That's good. That's the way I understood it. I do want to move off to another issue, but I don't know if the other commissioners had questions on the labor questions. The next one I have questions on is Section 4 of the settlement. And that deals with a particularly new statute that we have not had a reason to enforce yet. This is the provider of last resort. I guess that's not the exact word. What's the term you guys always use?
Obligation to serve.
Yeah, obligation to serve. So we've allowed you under Minnesota Statute 237.181 to back away from that if you can show there's plenty of other things out there. And so this settlement delves into what it looks like if one of those are brought. At least you've agreed to some things with the department and OAG, okay? And so I'm looking at, and it basically says this in 4.1, upon the commission's approval of a petition to discontinue telecommunications services under that statute, okay, Lumen shall, and then it goes through a bunch of things, removing posts, okay, things like that, all good things that I probably would be okay with when I get to a petition like that. But I just wanted to be clear with you, no such petition is in front of us right now, and that you don't perceive this as being the limits of our authority, the parameters and things that you're required to do under this settlement. We may have some additional conditions that we might want to put on such a transaction, which we're allowed to under the statute, is my understanding. So, for example, if I wanted you to remove the post and also dig up all the cable underneath, all the copper underneath the thing, I don't know if that would be it. But if I have a record and I have a city that comes in front of me and they lay out some other infrastructure they want removed, that is something we could consider and weigh pursuant to the statute, and we're not bound by this settlement. Is that your understanding?
Thank you, Chair Tuma. It certainly is the case that the commission retains the authority it has under statute, and that statute requires a transition plan. There is not a petition pending right now. We're not able to do so under the statute till July 1st of 2026. I think in that transition plan, while we certainly may fight about removing cables, we understand that the commission has been granted authority to come up with a transition plan that addresses concerns related to consumers.
And to the department and to OAG, I appreciate these are good conditions that I would want to see probably in a future plan. That's just me, one of 5 commissioners. And certainly that's something I would anticipate that you would argue. They would probably say, hey, we're going to point to this as some precedent, that somehow this is what we've agreed to in the past. But you're not saying that this, if we approve this settlement as it is now, it is not binding. I could do something more in these that would be under the settlement terms. I could do something more if the statute gives me authority and the record would support that. Is that your understanding?
Chair Tuma, that's right. We just see this as committing Lumen to take certain actions, and it doesn't limit the commission's ability or authority to take other actions.
Mr. Dornfield, that's your understanding?
That's correct, Chair Tuma. While we're very proud of the settlement, we don't purport to have the authority to bind the commission a third party by settlement or its authority.
You've seen, Mr. Top and Mr. Zimmer, the decision option I put together. I just threw it together because I want to confirm the settlement. I don't know if you have that to put up, the modification to number 3. It's basically just saying that we're approving the transaction subject to the settlement.
That's the option that was filed late last week. Yeah, I would note there were some minor typographical corrections that Mr. Dornfeld filed with the commission just recently, and so we'd want to incorporate those, but yes.
Chair Tuma, Commissioners, we took revised decision option 3 that was filed by commission staff, and just tweaked that slightly to incorporate some modifications to the settlement that were necessary. And frankly, there just wasn't time to execute an amendment to the settlement. So in adopting the settlement, the parties would request that the commission adopt it as modified in what we've just titled decision option 8.
So I don't have it in front of me, so why don't we take a 5-minute recess, and I want to get that in front of me and also in front of the commission so the record is very clear. We're adopting, you would recommend 1 and 8 and that only? Is that what you're recommending, Mr. Dornfield?
Chair Tuma, we don't think that decision option 1 is necessary if you adopt decision 8 or frankly revise 3. If you're accepting the settlement, you don't have to determine whether there's approval is required under the statute.
But your 8 is a replacement to 3, is that what you're saying to me?
That's right. It's decision option 3 with a slight tweak to incorporate some
We'll take a break until 11 o'clock. Commission is in recess. Okay. Yep. Okay, now we're back. Despite your belief, on occasion we are confused. And my apologies. To your credit, first docket I worked on this week was yours, and so I didn't look at filings on Wednesday afternoon. So my apologies. We have a filing decision option 8 filed by the Attorney General's office on November 19th, and it is in the record. We confirmed that, so we're good. And this is decision option 8 up there in its entirety. First question to the companies, are you okay with decision option 8? I'm assuming you are, because it says it's just making some modifications, so.
As Jason Top from Lumen, yes, we support these.
And you're okay, just 8 alone?
That's fine, sure.
Chair Tuma, yes, AT&T is in support of decision option 8.
Don't need to ask you guys because you filed it, so, and the department, I'm assuming everybody's okay.
Chair Tuma, the department filed it, so I'll defer
Oh,
to Ms.
department
Raymond.
filed it, sorry. That's right, you got your wall of, the cone of silence between you, yes.
Yes, Chair Tuma, the OAG supports decision option 8.
Any other questions on decision option 8 in front of us or on the docket? Seeing no questions, I will move decision option 8 as presented in the record on November 19th by the department through their attorney at the Attorney General's office. All those in favor of that motion signify by saying aye.
Aye.
All those opposed, nay. Motion carries unanimously. With that, I think the sentiment amongst us is to just keep plowing through and see if we can get this wrapped up. And so with that, let's move on to item number 6, ITC's petition for an 8.5 mile, 161 kV line in southern Minnesota, Jackson County. Mr. Harvey, when you are ready, parties, please come forward because there will be questions, as I'm sure you've already anticipated. If you're online and you're participating, turn your camera on. We're just waiting on the dean of our facilities unit, Mr. Hartman. Let's do number 6. Go ahead.
Good afternoon, Chair Tooman and Commissioners. Item number 6 is docket number ET 6675 TL 24-232 involving ITC Midwest LLC in the matter of their application for a route permit for the approximately 8.5 mile, 161 kilovolt transmission line from the Fork Switching Station to the Rost Substation in Jackson County, Minnesota. The questions before the Commission are, should the Commission adopt the Administrative Law Judge's findings of facts, conclusions of law, and recommendations? Should the Commission find the environmental assessment and the record created at the public hearings address the issues identified in the scoping decision? Should the Commission issue a route permit for the approximately 8.5 mile, 161 kilovolt transmission line and associated facilities? Staff has the following opening remarks. A amended decision option was filed earlier this week. It is titled TUMA Amended Decision Option Number 5. There are copies in the back. It states the proposed route permit attached to these briefing papers for the ITC Midwest LLC Fork Switching Station to Ross Substation project in Jackson County, Minnesota, with the following modifications. Modify the following sentence at the bottom of page 3 of the proposed permit. The route width studied was 1,500 feet, 750 feet on each side of the center line. However, the authorized route width is 1,000 feet, 500 feet on each side of the center line. The actual right-of-way will be 100 feet, 50 feet on each side of the center line. B, clarify in section 3 and 4 that the route designated and anticipated alignment is as depicted on the maps provided by applicant's November 12th, 2025 response to staff's information request. Number 1, for the purpose of the permit, the proposed alignment as depicted on these maps is the permit's anticipated alignment. C, attachment 3 to the route permit shall be the 5 maps showing the 1,000-foot route width filed by the applicant on November 12th, 2025. Staff has no further remarks and is available for questions.
Ms. Herring, why don't you introduce yourself for the record?
Good morning, Chair Tuma, Commissioners. Valerie Herring from the Taft Law Firm, appearing on behalf of ITC Midwest. Appearing virtually for the company are Ken Price, Supervisor of Transmission Line Design, Jason Smith, Real Estate Specialist, and Holly Fisher, Senior Legal Counsel.
Are we doing this? Okay, good, sorry. Give me my rationale just first, and I don't know if you have any concerns, but I think that it's important to understand the rationale. We've had other developers in here before who kind of misunderstand and misinterpret Articles 3 and 4. I'm comfortable with your 1,000-foot if we have clarity on what those conditions are within that particular section of the permit. We had recently done a couple where they're closer to 400 feet is the route width distance, and then we do some expansion based on particular pinch points that maybe you've basically said to us, we're happy with the 1,000 feet. And I agree with you. There's not a lot going on in this 8 miles. It's pretty monolithic. The whole area is cornfields and soybean fields, so we're not crossing over major waterways or going by any dairy farms that I can tell. There look like there's a few hog farms, but nonetheless, it seems like your alignment was appropriate. You're moving the alignment, and I think what's important to understand is the alignment means something, okay? That is the starting point. The 1,000 feet gives you flexibility to do things for 2 reasons. One, unforeseen circumstances. That's not something as simple as, oh, I didn't know there was a fence pole there. I mean, it needs to be like there's an archaeological site or a karst structure that we weren't aware of. That's unanticipated situations that are there. Or landowner agreement, and that's both landowners. We had some people in front of us thinking that one landowner wants this and we're going to move it into your property and we're not going to ask you. We believe that's both landowners. And so those are the 2 reasons you can move off the anticipated alignment within that 1,000 feet. If you need to go beyond that 1,000 feet, we have another process for that in rule and statute for a minor modification that does have to come back to us. When you move it off the alignment, you still have to go to our staff and at the plan and profile, justify it using the factors. And so, again, a couple feet, that's what we would refer to as some minor moving back and forth from the alignment, because your maps were kind of vague. I picked your most detailed map, and so we understand that that's not a surveyed line, okay? So it just generally needs to be along that alignment. And that's what we anticipate going forward. You're not lord of the 1,000 feet. You don't get to move wherever you want within it. You have to work with landowners, and that's what we expect from you going forward. And so that's the intent of decision option 5, the amendments, is to clarify what maps we're working from and clarify specifically what the alignment that we are dealing with in the permit. Is the applicant okay with that?
Chair Tuma, ITC Midwest supports your amended decision option number 5.
Excellent. Those are the only questions I have. I'm comfortable, like I said, with 1,000 feet because that is there for flexibility working with landowners, and we anticipate you will continue to work with landowners as we do this. I think it was important to recognize that this is a green field between 2 existing already kind of where we could have co-located it on some existing structures. We chose not to do that, and I think it's important to say why is because of reliability. That's what you laid out, and that's what the ALJ found, that this particular route ensures greater reliability. There's a lot of things going on there, and we want to make sure that we can get the power out of that area, and so that's what this is accomplishing. So I'm comfortable with the fact that even though there are some other structures there we could work with, this green field for the overall area makes the best sense as indicated in the ALJ's findings. So, Commissioner Hom.
Thank you. Chair Tuma, so I'll start with something positive. Yeah, thanks for our staff, Mr. Hartman and Mr. Beer. So their work is well reflected in these dockets, and I think even we had a further distance trying to develop the record better with the sending IR and trying to make sure that we make an informed decision and then developing overall record. I appreciate both of you, your work. Being said, I had some concern with the company's reaction to the information request. I think I made this statement last week with another ones, but our staff on Department of Commerce staff sent the information request not for the fun. Try to make a record clear and better. And when applicant respond to that information request with good effort, not just sake of responding to the record, the information request is not a good thing. But the way I read this information, the response to the information request was too vague still. And that's why Commissioner Tuma made this discussion on the 1,000 feet versus a 1,500 feet discussion issue. We need rationale. Commissioner Tuma had a lot better rationale than company's response to that information request. So I hope that company has some way of improving your way to manage or deal with the regulatory process, because I have a concern because ITC is one of the applicants of many MISO projects. So I hope you guys learn the lesson from here, even though it's a short distance line. I think regulatory process doesn't matter, short or long. I think your action in preparing application makes huge difference. So that's the concern with how you respond to the information request. The second is, I know this is not a certificate of need, the dockets, but also I hope we have a more clarification and clear reasoning for the need, because now public is asking questions. Doesn't matter whether it's a certificate of need or routing proceeding. They want to know why they have to sacrifice their land. So hopefully we can have a more clear engineering answer to it, such as clearly showing NERC reliability requirements, what you are trying to respond to. I understand it's a multiple party project. In addition to this project, you have to work with the Great River Energy and Missouri River Energy Service to improve the area reliability. Yes, that's a great thing, but I think you need to put a little more information to make sure that it is just not just you saying it, but there is such a requirement by federal entity you have to abide with. So we are approving this routing, considering all those understanding. And another reason I am making this statement is I think there's a lot of concern going on in the large-scale level that this kind of small project is not being properly evaluated by state, and then Mid-Continent ISO is not properly evaluating at their annual process. And that's why I think we have to improve our application to make sure that and then show people how state is properly evaluating overall, particularly alternative analysis on this thing. I know, once again, this is another CN, but people has a concern that if there is a non-transmission alternative, these days GATS are being used a lot as a terminology, but non-transmission alternative is properly evaluated at this before you ask for this specific routing. That is a very significant part of the concern by everybody in the nation, that because affordability is a huge issue, if you can achieve same reliability without building new line, you should address that to the public. And I think we owe the public up to that much to make sure that we are eyeing on every sense of the potential of their rates. Once again, this is most likely for the co-ops and muni rates because we are serving that area. but also we do care because there are people in the Minnesota. Being said, thank you for your work, but I hope you have some room to improve in this certificate need or routing process and transmission line process. I just want to make sure that that message is being delivered.
Sir.
Commissioner Tuba, Chair Tuma, Commissioner Hahn, I appreciate those comments and I will take those back. It seems like you're raising some larger issues that may be better addressed in some future applications, and we'll certainly take those comments back to the company.
Excellent. Partridge? Good, looks like. I have the motion. I'll move a decision option 1, 2, Tuma amended decision option 5, as filed November 20th, and 7. All those in favor signify by saying aye.
Aye.
All those opposed say nay. Motion passes unanimously. Thank you. We are adjourned.
Yes, because